Good afternoon, everyone. I call this meeting to order. Welcome to meeting number 117 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April 24, 2023, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. Once again, I would like to welcome our witnesses today and thank them all for being here. From the Department of Industry, Mark Schwan, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector, accompanied by Sami Shabra, Director General, Marketplace Framework Policy Branch. And we also have with us Runa Angus, Senior Director, Strategy and Innovation Policy Sector. Thank you all for being here once again. If I were to go by where we ended at the last meeting, Mr. Turnbull was the speaking and had raised a sub-amendment, if I'm not mistaken. Mr. Turnbull.
My colleagues, and thanks to the officials for being here. I know you'll spend some time with us over the next couple of months, and we look forward to working with you and getting to know you better. So I had asked the officials numerous questions to sort of set the stage for introducing a sub-amendment that at least we think is a bit of a compromise on the language and provides further clarity. So it's taking out some language a little bit, but also based on some arguments that were made last time, and hopefully those clarifications were helpful for committee members. So this was drafted by my colleague Iquinder, who is here, but I'm introducing it today because he was absent last time and I was intending on doing it then. So I just want to thank my colleague, Mr. Gahir, for his work on this. And so I'll read it into the record, Chair. That motion CPC 1 proposing to amend Clause 2 of Bill C-27 by adding a preamble after line 7 on page 3 be amended by A, replacing, in quotes, whereas Parliament recognizes the importance of the privacy and data protection principles contained in various international instruments, end quote, with the following, whereas Parliament recognizes the importance of privacy and data protection, end quote. And B, replacing, quote, whereas the processing of personal information and data should respect minors' privacy and their best interests, end quote, with the following, quote, whereas minors actively take part in the digital and data-driven economy and their personal information is worthy of stronger protection given their varying levels of capacity to understand how it is used by organizations and the potential long-term implications of such use, end quote. And C, deleting the following, quote, whereas the design, development, and deployment of artificial intelligence systems across provincial and international borders should be consistent with national and international standards to protect individuals from potential harm, end quote. D, replacing, quote, whereas Parliament recognizes that artificial intelligence systems and other emerging technologies should uphold Canadian norms and values in line with the principles of international human rights law, end quote, with the following, quote, whereas Parliament recognizes that emerging technologies should uphold Canadian norms and values in line with the principles of international human rights law, end quote. Thank you, Chair.
Thank you, Mr. Turnbull, and I believe colleagues have all had a written copy of the sub-amendment referenced 1299-1258 by Mr. Gahir, moved by Mr. Turnbull. So we'll now open debate on the amendment proposed by Mr. Turnbull, sub-amendment. Mr. Viss.
Thank you, Mr. Chair. Thank you to our officials for being here today. Again, I was a little I'll start with my notes, I guess. In the last meeting, I did introduce conservative amendment CPC 1, which would amend the preamble to include the fundamental right to privacy and include text that would state the processing of personal data should respect minors' privacy and their best interests. This sub-amendment clearly deletes the best interest clause. I will note in good faith, later on in the amendment process, there is universal agreement on the fundamental right to privacy. So my real concern here is the second phrase that's being deleted, and that's respect minors' privacy and their best interests. So I put forward this amendment, as it was one of the key recommendations tabled by the Office of the Privacy Commissioner. In the Office of the Privacy Commissioner's submission, they recommended that in addition to putting in a fundamental right to privacy, which I think there's unanimous agreement on at this committee, the preamble should also reflect the importance of protecting children and minors. Jurisdictions around the world have recognized that children and minors may be impacted by technologies differently than adults, be at greater risk of being affected by privacy-related issues, and therefore require special protections. I think there's broad unanimity at the committee that that is the case, too. The Office of the Privacy Commissioner said that updating the preamble in such a manner would encourage organizations to build privacy for children into products and services from the start and by design. And since Canada's privacy laws were designed to be technology neutral, this would help ensure that the best interests of children would be considered for new and emerging technologies and for future uses of data. Adding the proposed language to the section that frames the legislation's intent would help ensure that the best interest of children and minors are prioritized and consistently considered across all related bills. I believe that the law should recognize the rights of the child and the right to be a child. Taking in the concerns of the pushback on this language from the government and some of the comments made by you, Mr. Shan, at our last committee meeting, I did host a meeting with the Privacy Commissioner yesterday, asking him to further emphasize the importance of including this language with C-27, and I will note that Mr. Massey did join me at that meeting. In having this important meeting, the Commissioner gave some key insights as to why it is crucial to keep the best interests of the child language within the preamble. So my first question to you, Mr. Shan, in the last committee meeting, we heard that the term, the best interest of the child, was a subjective construct. In speaking with the leading experts in this field, I have to say I don't agree with your interpretation and and the way you phrase that term. So can you provide us the legal opinion that led to you making that statement on behalf of the department at the meeting?
Thank you, Mr. Chair, for the question. The
Microphone, please.
for regulations with that. Oh. There we go. Thank you, Mr. Chair, for the question. The drafting process for amendments considers both policy and legal considerations. And so our recommendation that best interests might be less interpretable than particularly the capacity indications that we've indicated in the government amendment is a mixture of those. And so I'm not in possession of a legal opinion that I'm able to share with the committee.
In my discussion with the Privacy Commissioner yesterday, he referenced a couple of existing case law in Canada that he said related to the best interest of the child. In fact, he gave me a couple of examples where the best interest of a child was included. The first example is the case of K.M.N versus S.Z.M 2024 BCCA 70. The BC Court of Appeal allowed an appeal by a mother because the trial judge failed to conduct a proper analysis of the allegations of family violence by the father. The court, in this instance, recognized that the best interest of the child is of paramount importance in family law matters. This new judgment clarified that it is not sufficient to limit the best interest of the child analysis to evidence of violence specifically directed towards the child. More in 2015, we can also look at the 2015 case at the Supreme Court of Canada, Canthasamy versus Canada. In this case, the Supreme Court of Canada considered the best interest of the child and made a decision in the context of an application for permanent residence on humanitarian and compassionate grounds. It held that the decision makers, that being the Department of Immigration in this case, must identify, define, and examine the best interests of the child and consider them in view of the other relevant factors. Best interests of the child, in my opinion, is not a subjective construct. Provinces across the country have the best interests of the child written into many laws. Here is a list of the references where the best interest of the child is used in Manitoba family law, in BC family law, Alberta family law, Nova Scotia family law, Ontario family law, Northwest Territories, Prince Edward Island, Newfoundland and Labrador, Nunavut. But I just want to get down to that. Why would you say that it's a subjective construct when it's clearly a defined term that's used in the Canadian legal system already?
Thank you, Mr. Chair, for the question. And I appreciate the references that have been put on the record. I'd note that they're all in a family law context, and what we're at issue here with is the construct of the best interests of the child from a commercial context, given that we're talking about the commercial application of personal information in a transaction between a consumer and a corporate entity, for which those family law constructs are well understood in custody and various other family law contexts, but are not jurisprudentially established in a commercial law context.
Mr. Chair, I would also point out that the Canadian Bar Association has a document outlining their perspective on the best interest of the child, and they state, I'll say point number one from the Canadian Bar Association, and I don't believe this is reflective just of family law, but they said that the best interest of a child is a substantive right, and it should be a primary consideration in actions concerning the child due to a child's dependency, maturity, legal status, and often being voiceless in society. Second, the Canadian Bar Association outlines, in respect to the best interest of a child, that it is in fact an interpretive principle. If a legal provision is open to more than one interpretation, the interpretation which most effectively serves the child's best interest should be chosen. Thirdly, the Canadian Bar Association points out that the best interest of a child refers to a rule of procedure, legal representation, timely decisions, reasons for how a decision is reached, how factors were weighed, and how a child's view were considered. And I'd say fourth, the best interest of the child, according to the Canadian Bar Association, in their mind, is a substantive right and a guiding principle that covers the conventions on rights of the child, which is aimed at the child's holistic development and requires a rights-based approach that promotes the child's human dignity, adult judgment, and I don't believe this is subject solely to family law, cannot override a child's rights. So I will also point out that I did a quick analysis by the Library of Parliament, and they have a whole number of examples that where a child's best interest lie, and it actually goes beyond family law. It also relates to the treatment of Indigenous children. For example, an act respecting First Nations, Inuit, and Métis children, youth, and families, and numerous other cases that I'd be happy to share with the committee. That was done very quickly, but I did get that from the Library of Parliament. They gave me 50 different examples where the best interest of child is in Canadian laws, both at the provincial and federal level. So with that in mind, last year, the privacy, I'm just going to say that in response. So my next question would be, last year, the privacy commissioners across the country all signed a special resolution of the federal, provincial, and territorial privacy commissioners and ombuds with responsibility for privacy oversight, which specifically highlights putting the best interests of young people at the forefront of privacy and access to personal information. Mr. Shand, do you agree with the use of the term the best interests of the child in the joint declaration of every single privacy commissioner and the Canadian Privacy Commissioner when they put out that declaration in October of 2023.
Merci, Monsieur le Président. Je suis.
Thank you, Chair. I agree with the sentiments expressed by privacy commissioners. We were looking at ways of protecting the interest of children.
I'm not at all at odds with the directional push from privacy commissioners to ensure that there are appropriate protections in place for children.
Privacy Commissioner, along with every single territorial and provincial privacy commissioner in Canada, considered putting the best interests of young people at the forefront of this law. And I'm at a loss as to why the department, Mr. Chair, does not want to include the very language that our privacy commissioners at the provincial, territorial, and federal level of government have signed and requested we do in the documents that they unanimously agreed to. In those documents, putting the best interest of young people at the forefront of privacy and access to personal information, it's about building in a child's right to privacy by design. It's about being transparent. It's about setting privacy protective settings by default and to turn off tracking and profiling. It's about rejecting deceptive practices, limiting the disclosure of personal information, allowing for deletion or de-indexing and limiting retention, and facilitating access to and correct of personal information. All of you can find this document on the Privacy Commissioner's website. It was right on there. And again, I'm still at a loss from what I've heard today from the department officials as to why they would say this is a subjective construct. Ms. Denham, in response to the testimony from the last meeting, wrote to me, and she said, and she was the former Privacy Commissioner of British Columbia and the former Privacy Commissioner of the UK, where they embedded the best interest of a child into British statute law. She stated, and I quote, "I remain supportive of the Conservative amendment in the preamble. The best interest of the child is a legal test, not a construct, but a legal test used to decide what would be best to protect a child's physical, psychological, and emotional safety, security, and well-being. It is defined in the UN Convention on the Rights of Child, and Canada is a signatory. But in Canadian provincial law, and I will agree to this, that it generally means the decisions about the issues of child's related to guardianship, parental responsibilities, parenting time, when the child can decide something on their own, relating to the level, stage of maturity, etc. But," and she goes on, "I think it is critically important that privacy is a fundamental right, and special protection for children's and minors' rights is referenced in the preamble because the bill," and she goes on, "the bill also mandates that children's data must be considered sensitive data, and that is very important and impactful as well." So the Privacy Commissioner of Canada recommended that we include the best interests of the child in the preamble, which he also recommended be included in the body of the bill. The former Privacy Commissioner of British Columbia and one of the leading global experts recommended that we do that as well. But they're not coming from nowhere on this. The OECD, in fact, which Canada is a signatory to, has a recommendation on children in the digital environment. Canada is a signatory to this document. I read it today during question period. They said it's called the Recommendation of the Council on Children in the Digital Environment, and it's an OECD legal instrument document. And in the document, they speak about the best interest of a child. This is a legal international document that Canada has signed, and they recognize, the OECD, that Canada is a signatory to, that the digital environment is a fundamental part of children's daily lives and interactions in a number of contexts, including formal and informal education, formal and informal health services, recreation, entertainment, maintaining links to culture, socializing, expressing themselves and their identity through the creation of digital content, engagement with political issues, and as consumers. And they recognize that children's capabilities vary by age, maturity, and circumstances, and that actions and policies for children in the digital environment should be age appropriate, tailored to accommodate developmental differences, and reflect that children may experience different kinds of access to digital technologies based on their sociocultural and socioeconomic backgrounds and the level of parental, guardian, and career engagement. And they also recognize that safeguarding children's privacy and protecting children's personal data is vital for children's well-being and autonomy and for meeting their needs in a digital environment. That document also references the UN's rights in the digital environment for children, which states that the best interest of the child is a dynamic concept that requires an assessment appropriate to the specific context. And what we're doing here and what the sub-amendment doesn't accomplish is that it doesn't allow for that very specific language that is well defined that in documents Canada is a signatory to, including the OECD, the G7, which I will get to, as well as other various state American laws that I will touch upon too. The UN states that state parties should ensure that in all actions regarding the provision, regulation, design, management, and use of the digital environment, the best interest of every child should be a primary consideration. So Canada is a signatory to that document as well, where they outline it. I'll just go back to the OECD for a second. For their guidelines for digital service providers, which aims to support digital service providers when they take actions that may directly or indirectly affect children in the digital environment, in determining how to best protect and respect the rights, safety, and interests of children, recognizing that girls, children belonging to racial, ethnic, and religious minorities, children with disabilities, and others belong to disadvantaged groups may require additional support and protection. And that document states that to limit the collection of personal data and its subsequent use or disclosure to third parties to the fulfillment of the provision of the services is in the best interest of the child. Again, Canada is a signatory to that document. Internationally, there was a resolution by data protection authorities from around the world on children's digital rights, and that was signed by Canada's Privacy Commissioner as well. And that states, affirming that in the implementation of policies relating to the rights in the digital environment, taking into account the evolving capabilities of children and their best interests must be a primary consideration. I'll go on. France, a trading partner of Canada's, their commission outlines, and I quote, in order to support young people, parents, and professionals develop a digital environment that is more respectful of children's best interests, the CNIL has published 8 recommendations stemming from a review conducted with all stakeholders concerned. So France and their laws recognize the best interest of a child. Ireland's data commissioner has a core message that the best interest of the child must always be a primary consideration. But one which is very, very important is the G20 digital ministers call for actors involving in the digital environment to uphold the child's best interest. So Canada is a signatory to the G20, outlines that the best interest of the child in the digital environment must be taken into account of our policy development and our legal rules. So that's in response to what you just said. But what do you feel about, Mr. Shan or any other department officials, is California an important trading partner for Canada?
I think you'll find from the statistical data on trade flows, yes.
What importance does California have in the development of technologies that might be applicable to Bill C-27?
I think that, Mr. Chair, I'm not sure I'm in a position to offer all of the ways in which California is engaged in technological development, but I'd say that obviously they're a tech center.
Okay. From what I understand, and I think you would probably agree with this, many Canadian companies in the tech sector do business with tech sector companies in California. Is that a fair assumption?
Again, I'd say California is a locus of activity related to the tech sector. Insofar as Canadian companies do business with them, I think that would vary. But
okay, in California, Mr. Shan, through you, Mr. Chair, there's called the California Age Appropriate Design Code Act. In that act, it states very clearly that if a conflict arises between commercial interests and the best interests of children, companies should prioritize the privacy, safety, and well-being of children over commercial interests. This is in the law that governs the largest economy in the United States. This is in the law where more technological development takes place anywhere in the world, and I am still at a loss why the department would state that the best interest of child is a subjective construct. Please answer.
Mr. Chair, I hope I've been clear that I think our considerations and commentary on the record are that in a commercial context, the interpretability of this term may pose challenges for implementation by corporate entities in terms of their understanding. So I think we've spoken to the fact that the established tests to be able to understand that at the part of courts or parents are important considerations, but that as it relates to the commercial context, that there may be better ways at being able to express the exact same concern about the stronger protections required.
Mr. Chair, we did not hear from a single witness that disagreed or did not believe that the best interest of child was a concept unworthy of being in this legislation. Throughout the initial parliamentary debate and everyone we've heard from so far, it's been very clear that in this changing and dangerous digital landscape, that we have to protect children. And in my meeting with the Privacy Commissioner yesterday, he very clearly stated that the adoption of this sub-amendment would reduce his ability to do his job and effectively enforce the protection of children's privacy rights. I'll also mention that I reached out to Mr. Michael Beauvais. He was another witness, and along with Professor Leslie Regan Shade, they said in response to the proposed sub-amendment, the overreaching problem with the proposed sub-amendment is its narrowness. Children are citizens and are more than just economic actors. Not mentioning the best interest removes an important tool in the regulator's toolbox to develop guidelines or regulations dealing with minors. The proposed sub-amendment suggests that minors' information is only worthy of increased protection because of their varying levels of capacity to understand, in brackets, how their personal information is used by organizations, and the use's long-term implications. It may lead, he goes on to state, to an interpretation that minors with capacity merit less robust protections. Even educated adults experience difficulties in understanding how organizations use their personal information, especially in big data context. He goes on, moreover, focusing on children as participants in the digital economy, as per the department's view, those are my words, takes too narrow a view. For example, the bill would apply to Indigenous bands regulated under the Indian Act. This is currently the case with the Personal Information Protection and Electronic Documents Act. While this is part of a broader issue, the draft language exacerbates the framing of individuals as consumers and economic actors. Let me just state very clearly, the Conservatives' position is that my job is to protect children, and I believe that's the same objective of everyone around this committee table. I, in good faith, looked very closely at the sub-amendment, and I cannot, in good faith, support this measure in its current form. We have to include the language of best interests of children. There is too much at stake that we don't understand. Before continuing on, I know I've been going on for a while now. I will note, and I'll just re-emphasize that in the first recommendation from the Office of the Privacy Commissioner, he requested that we put the preamble into the body of the bill. There was also concerns raised regarding the reference to artificial intelligence. When this bill was created, and yesterday we had some on Monday we had some semantic arguments about Schedule 1 and Schedule 2. We're not going to repeat that, Mr. Chair. But it kind of reminded me of my catechism class as a young man when we learned about the Holy Trinity, 3 in 1, 1 in 3, one being the same, consubstantial, begotten of the Father, not made. Francesco probably went to the same classes as me. This is like the Holy Trinity of digital bills. It's 3 in 1, one and the same. 3 are different, not the same, but all together. It's confusing, Mr. Chair. I am really confused, and I know some of the terms of the titles refer to acts, but they are in fact all three bills, 1 and 3, 3 and 1, one and the same, and I know Mr. Shan's having a good chuckle about that as well. So I will stop there for the moment. I believe I'm going to stand by the recommendations of the Privacy Commissioner in good faith, and I look forward to further debate on this sub-amendment.
Thank you very much, Mr. Viss. Mr. Perkins, and then I have Mr. Massé, Généreux, Turnbull, and Garon.
Thank you, Mr. Chair. I'm out of breath.
Well, and how do you think the
Interpreters
the interpreters feel? So I on that note, Mr. Perkins, because we opened that door, Mr. Viss, if you can speak a little more slowly going forward, especially when you read.
I had over 10 pages of notes.
It's appreciated, but for the interpreters, Mr. Perkins.
Yes, Mr. Chair.
Thank you, Mr. Chair. If I could take just a brief step back on this, and I want to acknowledge MP Turnbull's proposal to try and find a way to put CPC1 and NDP1 together, and acknowledge your opening remarks of saying that you're supportive of the idea of the preamble going into the legislation itself. So I want to thank the government for a genuine effort, I believe, to try and do the overall statement. And I on the actual proposed sub-amendment, that's the right term. I don't know, it says Mr. Gahir, but I think it's in your name now. I don't know if it's in Mr. Gahir's name, but our discussion here isn't about what would be, I think, C in this, which is C and D, which I think is the issue of the problem with the references to the Artificial Intelligence Act and the and bringing in MP Massey's an element of his amendment. I think I don't have a problem. We have total, I think, agreement with that. I think as MP Viss just pointed out, we're struggling with the loss of what we think is a very important concept in the best interest of the child. So I've got a couple things I'd like to ask questions about, and one thing just to make sure everybody's. But I guess Mr. Shen, or Ms. Angus, I don't know who's the appropriate one on this. Just to take a step, what we're talking about here is that the idea of the best interest of the child was stated in our discussion of these amendments. Last thing is a subjective construct. Now, that's a legal term, right? So I'm wondering if you could explain that for everybody who's watching to know why we're having this discussion, what a subjective construct is in terms of looking at legislation.
Chair, I'd offer that for the purposes of our considerations and much of what we'll likely offer as responses to questions over the course of the consideration of this bill is the interpretability of its implementation, which is to say that we are deeply motivated by ensuring that this bill can be understood and held accountable to the corporations of all sizes who use personal information in the Canadian context will be able to live up to it. And so from our perspective, I think our considerations and comments were in relation to the fact that for the purposes of the implementer, the corporation who needs to make a determination about the use of personal information, who are not necessarily afforded the efforts of a family court or have not sat and presided over significant kind of amounts of cases where this is their bread and butter, that being clear about the stronger protection required for minors' information is what we saw as pivotal to relaying, and hence our comments and considerations.
So, in other words, the term, if it was put in this bill, the best interest of the child, without some mechanism for defining what that means, would rely on the courts to interpret and companies to interpret what Parliament's intent with that was, because there is or there is not adequate case law to define that with regard to best interest of the child and privacy.
We'd imagine this would probably be a zone that the Office of the Privacy Commissioner would probably seek to issue guidance. We imagine that this would be a zone where there would need to be further guidance, either through jurisprudence or through the OPC, to aid commercial entities in understanding how they should interpret the best interests of the child for the use of personal information in the commercial context. And so this would apply, as this bill does, to every commercial entity operating with personal information in the country. And so all of them are going to need the capacity to be able to know what to do with minors' information, and to be able to understand their obligations. And so hence that's our interpreting frame. So yes, I think the answer to your question would be there will need to be some meat put around this, which will probably borrow from much of the case law that was cited by the honourable member and other instances to try and translate it into the real implications for a commercial entity in their transactions related to the personal information of minors.
So we had some lawyers. Not a lot, thankfully, but we had some lawyers appear before the committee on some of these things. Sorry, Mr. Gear. We had some lawyers appear not related to the bill in general. And with regard to another aspect of it, when we were discussing, I think it was around the terminology of legitimate interests and those things, they actually said there was case law around that definition, but not in Canada. In other countries, that courts would turn to as well in looking at that. So MPVIS went through, a law and presumably case law in other countries around best interest of the child. So doesn't that help already in guiding, say, the corporate legal counsels, advising people like me that were in the marketing field in large corporations, on what we should and should not do, and whether or not you had a internal privacy watchdog or not within the company? It doesn't just have to be Canadian case law, does it, in order to provide definition to best interest of the child?
So I think some measure of OPC guidance, international best practices can afford corporations in a number of these spaces the capacity to be able to know how and when to interpret its obligations. And I think international case law can be useful, but obviously always needs to be brought back to the kind of crux of what is their legal regime, what is their overall system, how similar or non-similar is it to ours, what obligations do they or do they not possess in terms of their authorities. There's a number of those questions, but certainly if I was an entity looking for inspiration as to how to start to interpret it, those would be amongst my places. But
I'm not going to get into the Schedule 1, Schedule 2 thing again, but I am going to make a reference to another section, if that's okay, which is Clause 122, in particular 122E, which is the clause that deals with the regulatory power of the governor and council. And it basically gives the governor and council the ability to make regulations with respect to this bill or this act, the replacement of the Privacy Act, on some very specific things in A, B, C, and D. But in E, it also says prescribing anything that by this act is to be prescribed. So if the preamble is now part of the opening of the bill as opposed, and therefore has some legislative and legal interpretive weight, does that not give the governor and council the ability to use regulation to provide some legal fence posts around what the government would see as the best interest of the child out of the starting gate?
Just a quick point of order, Mr. Chair. Do you have that page number?
Yeah.
60, thank you.
61.
Thank you. Thanks.
Thanks.
I've had enough correspondence with the Standing Committee on the Scrutiny of Regulations to know better than to provide a definitive answer to Mr. Perkins as to whether or not the regulation-making authority in E would compose sufficient room to issue regulations on the basis of the preamble. But to say likely not, because normally a statute needs to indicate that regulations are to be prescribed or use terms like a prescribed entity, and then you draw on the power of E to say what those prescribed entities actually are. As I say, I'm not gonna be definitive, but all that to say is, if this term ends up in the preamble, as I've noted, it's the likely space by which OPC guidance would probably be forthcoming.
So in a number of areas that the Minister of Innovation, Science and Industry oversees and his responsibilities, he has issued policy directives. I'm thinking of things around Investment Canada Act. I'm thinking of things already around artificial intelligence, for example, and codes, voluntary codes. When this becomes, if this amendment passes and becomes law with the term best interest of the child, and if you believe, and the lawyers believe that you can't use Section 122 to define it under regulation, can you not provide some similar policy guidance for companies and anyone else in the public that wants to understand where the government sees the fence post being on this definition? I know it doesn't have the same legal standing, perhaps in court, but it provides a sense of guidance and intent, does it not?
We have the interpretive authority of the CPPA will be the same as the interpretive authority of PIPEDA, which is the interpretive authority is the Office of the Privacy Commissioner. They hold the capacity to interpret the statute as enacted. There is a capacity for the minister proposed under the CPPA to ask the commissioner to issue guidance and to take up this particular any particular issue as it relates to issues of import related to the interpretation of the Act.
Well, that's interesting. So in other words, you can issue guidance, not necessarily the government, the privacy commissioner, and that brings me to the document that MP Viss referenced that was issued on October 4th and 5th, the conference, the 2023, signed by the federal and provincial privacy commissioners. It's on the website of the Office of the Privacy Commissioner of Canada. And just so for folks who are watching, and I know there are a lot of people watching this because we get emails and texts and phone calls after every meeting about what we got right or wrong too. There seem to be a lot of lawyers, all lawyers watching this. I'll start. It says, I'll start just and say that the opening of it is called the context. So what it says is, Canada ratified the United Nations Convention on the Rights of the Child. Then there's a long URL that links to it in 1991. That would have been by the Mulroney government. The UNCRC affirms children's rights, including the right to privacy, and introduces the concept of the best interests of the child. The concept implies that young people's well-being and rights be primary considerations in decisions or actions concerning them, directly or indirectly. As a guiding principle, this concept can be applied in a variety of contexts to help assess and balance the interests of young people against others. In over 30 years, the UNCRC has had a tremendous influence on young people's rights around the world, including privacy. Many jurisdictions have recognized that young people may be impacted by technologies differently than adults, be at greater risk of being affected by privacy-related issues, and therefore require special protections. Some of the most authoritative and current policy and legal instruments that focus on or include provisions for young people's right to privacy are, and there's a list of them here. I won't go into the URLs, but the UN General Commitment number 25 on children's rights in the digital environment, which supplements the UNCRC. The next one is the OECD. I think my colleague referenced that, the Organization for Economic Cooperation and Development, of which Canada is a member. A Council recommendation on children in the digital environment. There's a URL link. And there's another OECD document called Guidelines for Digital Service Providers. It goes on, there's another reference, the Age Appropriate Design Code, which is on a children's code, obviously created by, that you're aware, the UK Commissioners, the UK Information Commissioner's Office. There's a resolution on data protection authorities from around the world on digital rights. France's Commission Nationale de l'Informatique et des Libertés, excuse my French, I'm working on it, recommendations to enhance the protection of children online. Ireland's Data Protection Commissioner's Fundamentals for Child-Oriented Approach to Data Processing. Then, as my colleague Mr. Viss referenced, the G20 digital ministers call for actors involved in the digital environment to uphold the child's best interests. The next document they reference is the California Age Appropriate Design Code Act, and then the EU Digital Services Act. It goes on to say these initiatives and many others recognize that the digital environment presents many opportunities for young people, but they also are a necessary response to the well-documented harms to young people, such as mental health-related harms. These initiatives are promising, but the signatories believe that there is still work to be done in Canada to ensure that young people are protected from these harms through legislative measures to make their best interests a primary consideration in the design of products and services that concern or impact them. Therefore, the next section, Canada's privacy commissioners and ombudspersons with responsibility for privacy oversight call on the respective governments to put the best interests of young people first by taking immediate action as necessary to, and it's a series of bullets, protect young people from commercial exploitation and the use of their personal information to negatively influence their behavior or cause them harm. Next point, to promote the privacy rights of young people, review, amend, or adopt relevant privacy legislation to be consistent with internationally recognized policy and legal instruments to ensure adequate protection of the privacy rights of young people. And the final bullet, require private sector organizations that collect, use, and disclose the personal information of young people to implement strong safeguards, be transparent about those practices, and enhance access to effective remedies for young people. The signatories recognize that the privacy rights of a young person are their own rights. Any limitation to their exercise, e.g. vis-a-vis parents, guardians, or public bodies, must start from that principle, be specific and limited to the particular circumstances, and be consistent with the best interests of the young person. The signatories also recognize that privacy rights apply both within and outside of their digital environment. With this resolution, while this resolution mainly focuses on the digital environment, its principles should be broadly applied. The signatories highlight that young people's personal information is particularly sensitive. The bill addresses that with the definition. Any collection, use, or disclosure of such information must be done with this in mind. The signatories recommend that public and private sector organizations adopt the following practices, which also reflect principles that should guide legislative reforms. 1, build in young people's privacy and best interests by design. Digital privacy risks to young people should be identified and minimized as early as possible. Organizations should ensure that privacy and best interests of young people are built into the product or service right from the design stage. Organizations should conduct privacy impact assessments for projects involving the data of young people or to examine the specific potential impacts on them. Adopt their traditional PIA process to think specifically about the perspectives and experiences of young people as individuals and as a group before collecting, using, or disclosing their information. And I know that the officials are very familiar with this, but I'm not sure everyone who is watching is. So the next point on what organizations should do is that they should actively involve young people, the parents, guardians, teachers, or child advocates in these assessments, and conduct intersectional analysis to consider specific privacy risks to vulnerable groups of young people. For example, those with disabilities, First Nations, to SLGBTQI plus, two-spirit, lesbian, gay, bisexual, transgender, queer, intersex plus people. Section 2, be transparent. Transparency is necessary for informed decision-making and consent. Organizations must provide privacy information to young people and their parents and guardians as appropriate in a concise, prominent, and clear manner suited to the maturity of the young person. It must inform young people of who to contact if they have questions about information presented. 3, they must be transparent about the privacy risks associated with using their products or service. This could include information on their special efforts to protect young people from these risks. 3, set privacy protective settings by default and turn on tracking and profiling, and there's a whole list of things there. 4, reject deceptive practices. These things include things young people must not be influenced or coerced into making privacy-related decisions contrary to their interest. Organizations must not incorporate into products and services manipulative or deceptive design or behavioral incentives that influence young people to make poor privacy decisions or to engage in harmful behaviors. Encourage young people to provide more information than what is necessary to use the product or service or to turn off protective privacy settings. Organizations should design products and services intended to empower young people to make informed privacy protection choices and take assertive action to advance their privacy and transparency limits. There are a few other ones. Limit the disclosure of personal information. There's some more guidance for organizations. 6, allow for the deletion or de-indexing and limitation on retention. Again, more guidance for organizations. 7, facilitate access to and correction of personal information. And in that, it says young people have a right of access to their personal information. That right is fundamental to ensuring that the information is accurate, up to date, and retained for appropriate purposes. The right of access also serves to hold organizations accountable. All organizations have a general legal responsibility to provide timely and complete access to young person's personal information upon request from that person, and in most cases upon request from their parent or guardian. It is recognized that a parent or guardian's access to information may be limited by a young person's privacy rights as is qualified by the individual's best interests and dependent upon the particular facts in each case. It goes on to describe more responsibilities for an organization and has a number of footnotes and reference, and you can see the logos of all the various privacy commissioners are on there. So you said you expect that the privacy commissioner might issue guidance and that he or she has the ability under the Act to do that, and that would probably be of more value, or that would be the appropriate route. But the privacy commissioner has already done that. That looks pretty specific to me. Now, he could reissue it under the power, I guess, once this bill goes, but it's pretty specific guidance right now. I don't know how an organization in Canada wouldn't understand the guideposts that have been set out. They're very detailed and clear in this. Perhaps the privacy commissioner would provide even more detail if this provision on best interest of the child is passed. But to me, I'm struggling, as my colleague MP Viswas, with the claim that it's subjective. It doesn't look subjective to me. It looks very specific. that privacy experts have defined this very well. So we struggle with the idea that the removal of that term is something that the government wants to do, rather than provide that term in legislation for not only the courts to interpret, but as you pointed out, to allow the privacy commissioner to give very specific guidance if he thinks it needs to be more detailed than this, under this act. But without the term best interest of the child in the act, it's difficult for the privacy commissioner to provide that legal guidance that you referred that he has the power to do on that terminology, is it not?
Thank you for the question, Mr. Chair. I think the goal of providing guidance on stronger protections, I think, is what we imagine the privacy commissioner would rely on.
So, would the privacy commissioner? How can the privacy commissioner issue guidance on best interest of the child if that's not the terminology in the Act? Because he can't issue guidance on something that doesn't exist in the Act.
I think what I'm indicating is that the general construct of the stronger protections for minors would both be elucidated through the specific obligations that are actually contained in the CPPA, and then would be the subject of guidance in terms of actual implementable capacity for an organization. So not just the sort of general value of the best interest of the child as an interpretive frame, but the actual specific ways in which an organization would be able to draw on that in making a determination, for instance, on a disclosure of personal information or a specific use of a piece of personal information.
The department or the minister talk to the privacy commissioner about this proposed change to our amendment before tabling this proposed sub-amendment?
We've had an ongoing dialogue with the Office of the Privacy Commissioner as it relates to this bill, including the government's potential areas for amendment.
Well, in our discussion with the Office of Privacy Commissioner yesterday on the specific wording of the bill, he has a different view than you just articulated. He said it actually narrows his ability, the Privacy Commissioner's ability, to actually issue guidelines on best interest of the child. Not using that terminology restricts his ability to provide guidance to organizations on that concept without the words in the Act. And I'm assuming the department's saying you don't agree, that it doesn't restrict it?
Considerations that we're looking for are around the ways in which organizations can provide stronger protections for minors, and so I don't hold a specific view on whether or not this does or does not do that in the specific ways that have been articulated.
I was almost finished till you said that. Sorry. Sorry. And I'm not. This isn't obviously. This is not a political discussion. This is a very specific thing that some of us who are marketing guys are trying to. We look at words differently than lawyers do. So, but when the department and the department's extensive lawyers, I presume the Department of Justice is part of looking at these things, decides to remove those words of best interest of the child and replace it with other words, they were trying to do so for a specific intent. And in the Privacy Commissioner Office's opinion, that specific intent is to narrow his scope. What was, if you don't agree with that, then what was the specific intent of removing the words best interest of the child and replacing it with language that other lawyers think narrows the scope?
The specific intent of the sub-amendment was to, in the absence of already issued guidance or guidance still to come, provide interpretability to commercial actors that would need to live up to this ambition from the moment of promulgation. And so the intent was to provide them with a clearer pathway towards living up to the Act, noting, as we have, that this inclusion would require further guidance.
So the words that you're proposing here, that the government's proposing here, aren't enough to provide the guidance. Something else will have to happen.
So the words that we provided in terms of worthy of stronger protection are consistent with the obligations that are found within the CPPA, notably the sensitive definition of information as it relates to the information of minors.
But it doesn't reflect the language of the many documents I outlined and MP Viss outlined that the Government of Canada has actually signed in accepting that our legislative frameworks should reflect the terminology that has been negotiated internationally, whether it's OECD, G7, or the UN Convention, that use the terminology best interest of the child.
The declarations outline the intent to get to an outcome of stronger protection for minors. And we believe that to be consistent with those declarations.
Then that terminology should be in the bill. If it's worthy of Canada signing it, then why isn't it worthy of Canada putting in the bill?
Mr. Chair, I don't have a response to that.
Okay.
Fair enough. Thank you, Mr. Perkins. I have Mr. Massey on my list.
Thank you, Mr. Chair. I'm going to try. First of all, Mr. Shannon, as a former vice chair of the Scrutiny and Regulations Committee, me and maybe about 3 other people got your joke. So, one of the most obscure committees in Parliament and so forth. But at any rate, and I do appreciate the government bringing forth this amendment. It's clearly to try to address Conservative and an NDP amendments that are very similar. But what I'm worried about is whether this seems more like a political compromise that then could very much, unfortunately, fall short for the legislation at the end of the day. Are you familiar with the UK's legislation? That's one of the things I would like to know, if you're familiar with the UK's legislation and what they've done with children in theirs.
I think if you're speaking about the design code for children, then yes.
Yeah. So they, under the UK Data Protection Act, and I won't read the whole sections for it, but they have really a robust section. They also talk about how children change over time as well too, and so forth, and other anomalies with it. Would you say that this amendment, or even what we've offered before, is stronger or weaker than the UK's protection of children in terms of what we have in front of legislation? Do you have an opinion as to that?
So I think the amendment we have before us is a preamble to the bill. If you're asking me about the bill itself and its actual obligations on entities as to their treatment of personal information, I would say we would suggest that the CPPA, as proposed, with a number of amendments that might follow, will allow for commensurate degrees of protection for children, including for the possibility of things like the design code to be a code certified by the Privacy Commissioner.
So, but how would it rank up to the UK? I mean, they have a UK's children's code as well too, and like I mean, I guess we don't have to do exactly what the UK does, but I'm just wondering whether or not we're setting ourselves up to do more, or we're setting ourselves up to do less than the UK. They fell also under the same legal system as Canada and parliamentary systems, so I think that there's a decent comparable there, because the United States doesn't fall in the same parameters in those two facets directly.
As I say, I think in pith and substance, with amendments, I think the CPPA will offer commensurate protection to children as that of the United Kingdom.
And so, what would be the, I guess, in your opinion, the downside of, okay, let's see if we don't go ahead with the sub-amendment and the other amendments then go through. What would be then the downside to the industries that would then be affected by this? And how significant of a risk really is that? And if we have to, we already have a problem in our world with child labor laws. Even Google was actually, and then we also have AI issues in building AI. We have a significant, problem as civilizations of even treating children, even despite these declarations, with humanity. I mean, you look at even the United States went through this last year with some of their supply chains having children involved in brand name, companies. So I guess what my concern is, at this day and age, why would we risk potentially, at least this is the information I'm getting for, is that this amendment would lessen this protection of children. Why would we risk that versus what is the benefit we get out of it?
So, Mr. Chair, I think the 2 points or considerations that we put before the committee are one, that we're desiring for ease of interpretability and implementation at outset of the passage of this piece of legislation, and that was our commentary around B of the sub-amendment. And then as it relates to C and D, it's to ensure that the preamble is specific to the legislation that it informs.
So you want clarity for the companies, but I mean, I can't imagine. So where's the big risk in this? I guess, is there a risk in terms of legal risk for the companies, or is it risk in terms of investment in Canada? In terms of not understanding if they with all the resources, all their lawyers, and all the money that they have, and everything at their disposal, can't figure it out, where are they going to be hurt from it?
Well, and I know the member knows well, Mr. Chair, but I'd say that the Canadian economy, so this bill applies to every single private sector organization transmitting and collecting or disclosing personal information. 99% of the Canadian economy are small and medium-sized enterprises who will have similar obligations to understand, interpret, and live out this act. And so I think important for us was that there is an ease of interpretability and of implementation for all of those commercial entities. And so I think the risk is, if there is ambiguity or uncertainty, that either they take actions that are ill-informed or potentially the wrong ones, or potentially they take no action and they instead choose not to engage in commercial service because it's simply too risky or unambiguous.
And that's a fair point, raising with regards to small and medium-sized businesses. I mean, we have these challenges and other types of policies related to taxation and so forth. So I take note of that, and that is a fair point in that. I guess my last question is going to be: is that if we do not pass this point in the bill, what would be the final, I guess? What would the government, or what would you see as an alternative as better? Is the changing or the amendments that are proposed that would come forth from that, without the changes?
So I can't speak for the government, Mr. Chair. I'd say if the sub-amendment fails, I think we would simply note our considerations around the interpretability, and then as I've said, the other two clauses of the sub-amendment which address issues for which we think might introduce either technology non-neutral language or potentially apply to acts that are not actually the subject of the legislation.
Okay, so we'll see when we get to that time, but a lot to think about for the short term. Thank you, Mr. Chair.
Merci beaucoup, Monsieur Massé.
Thank you, Mr. Massé. Mr. Généraux, followed by Mr. Turnbull and Mr. Gall. Mr. Chair, I'll yield my spot to Mr. Garon because we've taken a lot of time. I'm sure that we can allow each person to have one turn. I'll take the floor afterwards. I appreciate your generosity, but following the list that has been established, if you yield your spot, I will put you after Mr. Garon, and I also have Mr. Turnbull. I can go after Mr. Turnbull. So Mr. Turnbull, Mr. Garon.
Garon, if you put me back on the list.
Quel comité,
to go right after.
C'est le meilleur comité.
This is the best committee ever. Mr. Garon, Mr. Chair, I thought many people are giving me participation points, so I want to thank you for the opportunity. I'm trying to understand, when we talk about the best interest of the child in Quebec, this is something that exists. We have cited the case law that exists in family law. It also exists in civil law, so it's well understood and it's well defined. If I understand you well, if we used the term best interest of the child in the bill or in the law, the fact that there are 10 provinces that interpret it differently, that's one of the issues, one of the problems. That's one aspect. The difference here is is that the way we say it, the entity or organization that has the responsibility to interpret the consideration of best interest of the child is an enterprise. Who are the guides who have to influence any entity that has to interpret those concepts? And these are the reasons why we came up with these considerations. But there's another aspect. If a commercial organization goes along with its provincial interpretation, it may be different looking at the differences between the provincial laws. Question: there are federal laws that are interpreted differently in different provinces. I'm thinking, for example, about the law on young delinquents, because in Quebec, they take into account rehabilitation factors, and it's different in different provinces. That's not really a problem. Well, I don't want to spend an hour speaking like others. Well, I want to thank Mr. General sincerely for yielding his spot to me. I hope he's not regretting giving me the floor. First of all, the Privacy Commissioner could come up with an opinion, any opinion on whatever he wants. Are there restrictions on that? If we include the best interest of the child, the Privacy Commissioner, can he or she decide to come up with an opinion on what it means, yes or no? In my opinion, yes. Looking at the history of interpretation of the Privacy Act, entities can use their interpretative capacity broadly. There's a former commissioner that used the interpretative powers in a way that was broader. I understand, but the interpretation powers exist. The commissioner could come up with his interpretation and come up with opinions. You also have the courts that will be called upon to interpret the act and to come up with legal opinions and come up with guidelines. So the courts could also help Canadian or foreign companies to apply the laws for the best interest of the child. Is that correct? I can think of two considerations to answer your questions. First of all, the department thinks that there's a capacity for the courts to do so. If there's an issue or a case that goes up to the Supreme Court or the Appeal Court, it's not a problem. It's really at the beginning. It's the commercial organization that has to interpret those considerations at the beginning. I understand. So how is this different from any other act? We write an act or bill, is adopted in Parliament. We state that there are going to be interpretative notions. If we prevent legislation every time the courts have to come in, then we may all go back home. One of the objectives of the bill is to consider or give enterprises the possibility of interpreting the law. So we want to have rules that are simpler and clearer. Something else concerning the courts, because you mentioned that. The courts definitely have their own powers for sentencing. If there are facts that are established by commercial entities, it cannot be reconsidered. This confirms what I'm thinking, and this is something I told my colleagues. I have the impression that it may create a situation in Quebec where other people may be looking from outside. Well, it gives the impression that the law is written to facilitate the work of foreign enterprises. Quebec civil law is very complicated. The Canadian jurisprudence is too complicated. It's very expensive. We need to respect the imperatives of the courts, the companies are from California. They want to sell to our children. It's too complicated. Let's do everything we can to facilitate life for them. That is what it means. It gives the impression that a minister has taken a decision to go along with those companies. We do everything to facilitate things for the companies. And it's not the only place in this bill where we have the impression that there's this intention to facilitate things for the companies, where we know that there's also self-regulation and everything else. It's not the only place. I read the bill, and I have the impression that in spite of all the positive factors contained in the bill, we are trying to please the big companies. If we don't adopt the conservative amendment, I have the impression that we are putting aside the best interest of the child just because we want to please companies, and I don't like that. Thank you, Mr. Garon. I'll come back to Mr. General and then Mr. Turnbull. Thank you, Mr. Chair. If I had not attended these meetings consistently since we've been working on this bill for 1 year, I would have felt that you were witnesses appearing on behalf of the companies and that you were here to make sure that we facilitate things for the companies as much as possible. And that's the truth, considering that we are here as parliamentarians to adopt bills, not because we want to please industry, because we want to protect Canadians. So that's my perception. I may be mistaken. And the fact that right now the Liberals have decided to come up with a sub-amendment which eliminates a term that is globally recognized. We are not inventing anything. This is nothing political. We are talking about the best interest of the child, and this is something that is recognized throughout the world. Even in California, we said so before. Many American states recognize this. So I'm trying to understand the logic, and I hope that Mr. Turnbull is going to explain this further. I imagine that you're working together to clarify. We had 50 amendments, and now we have 3 bills, and there's a link, and particularly with what is coming up. I'm 62 years old. 30 years ago, internet just came into our lives. We were still using fax machines at the time. And now, with artificial intelligence, things are even going to speed up even more. And there are lots of dangers that will be faced by our children. It is our obligation to make sure that children are protected. I don't know. Well, I'll ask a simple question. If we do not, or rather, if we were to adopt the sub-amendment without adding that line, do you believe sincerely that children will at least be protected than if we were to leave it out? Thank you, Chair, for the question. I would like to make a few comments in French, but I will say something in English to clarify the point in French. To start, in my opinion, if the sub-amendment were to pass, it's the same protection for children and the same protections that are established in the bill.
I would note that comments about the ease of implementation should be understood quite distinctly from the rising obligations being placed on commercial actors, which are replete throughout this project of law, that the CPPA definitively increases obligations, penalties, and responsibilities for commercial actors for the use of personal information. And so I comment only on that because the comments were made about whether or not officials are appearing here on behalf of any other interests. And I would just like to be absolutely clear that a primary consideration for the departmental participation in the establishment of this law was to ensure the effective protection of the privacy of Canadians.
Merci, Monsieur Chan, mais
Thank you, Mr. Shan. I am not accusing you of anything. A while ago, Mr. Garon said he had the perception that people may be listening and think of something else. We have 250 amendments, and we're still at number 2 after 2 meetings. We had said we'll take this seriously. We started last fall, and from the very beginning, most witnesses said there should have been 3 acts and not just 1, at least 2, to separate the elements. But now they're in the same act. So we must take into account everything. And so what I'm saying is that the best interest of the children, considering what is going to happen in the future, this should be in the act. The terminology that is recognized globally should be contained in the act. And once again, I hope Mr. Turnbull will explain why the Liberals want to remove it absolutely. So I'll stop there for now. We'll come back to that later on.
Monsieur.
Thank you, Mr. General. Mr. Turnbull.
Yeah, thanks to all my colleagues for, I think, a really robust debate and discussion on this. I appreciate all your comments, and I think some really thoughtful arguments and questions to the officials. I think if I were to maybe start by saying, I think what we've expressed is a policy intent that is very much the same. Like, I think wanting to protect minors in a digital age where they are vulnerable to personal information being collected and used in ways that may not be in their best interest, I think is actually consistent with the overall objectives of the bill itself. And I think you've acknowledged that to some degree with some of the comments with regard to deeming all minors in personal information as sensitive. So I think we are aligned. I think there's, as the officials have said numerous times, I think the intent behind the sub-amendment, it was to try to provide interpretive clarity within the realm of commercial law, which is what I understand, that best interests is not a concept that's always known to companies. And I think Mr. Shan has made the point very clear. At the same time, what we're debating here is the language in the preamble of the bill. So I think expressing the intent that we all have, which I think we're aligned on, I think we should be able to compromise. And I would ask Mr. Shan a question. If you could just tell me, why do you have a preamble in a bill? Like, what is it really for? And it's actually kind of a very simple question, but I think it's fundamental to the debate we're having.
So a preamble obviously is a precursor to the fundamental obligations that a piece of law contains. And so the piece of law will follow with specific obligations and enumerate those in a number of ways. But obviously, a preamble gives the overall ambition and lens to those seeking to understand what those obligations are. And so it gives a sense of intent, and it also gives a clear notion of implementability of the obligations that then follow.
So in some ways, it just expresses the intent. It should be, and I think where we were coming from with this sub-amendment was to try and have a consistency among the approach and language to the bill, but perhaps more focused on the sort of legal interpretation of it rather than just the policy intent. Mr. Shannon, could you maybe just remark on that, whether like having the phrase best interests in the preamble doesn't necessarily have, because I mean it is the intent in some respects. So I think it does actually express the intent that we share, and I think we've heard that all around the table. It's just that it's also a legal term that exists in family law and doesn't exist in commercial law. So I understand how the legality of that term could impact on what we want to have in the preamble if we're focusing on interpretive consistency and expressing that. But if we take a step back from that and we say, hey, the purpose of this bill as parliamentarians and that we all agree is actually to really protect minors. So in my view, I'm sort of thinking, I was getting to a question, but could you remark on, if the ambition or the purpose of the bill were expressed in the preamble, including best interests, it doesn't necessarily change the nature of the bill, other than the fact that it would then be interpreted as wanting to protect the best interest of children.
I think the considerations we were attempting to put forward were about the use of consistent language that would ensure that the fundamental obligations that we see as so important that this law sets out are followed through on, which means that they're understood and can actually be lived out. And so insofar as there is the possibility of ambition being expressed in a way that maybe isn't the same exact way that it's then understood in the specific obligations, I think, as I say, it's a consideration around interpretability and legibility, but I think fundamentally the ambition that was proposed in the sub-amendment is the same.
That's helpful. And maybe just lastly to Mr. Jeannerou's points, and I think some other points that were made, which I think you sort of, Mr. Shannon, reacted to a little bit with your remarks. That when Mr. Jeannerou said that it sounds like you're here on behalf of corporations or something, and I heard other comments like that. I just wanted to say, from my perspective, our reason for being here and undertaking this really important work, I think, is very clearly to protect Canadians, to protect children. But it's also to ensure the interpretive clarity that is needed to be able to live up to those obligations. And that actually is in the best interest of children, right? If companies, small, medium-sized companies, can't interpret this bill in a way that they can abide by it and that there is ambiguity entrenched in it that they can't possibly fulfill, whether, maybe you're going to need a court opinion or something else, right? I think, so I just wanted to express the intent that I think we are aligned, that the ease of interpretation and the rise in obligations that you referred to are both parts of the same underlying objective and commitment. So I want to leave it there and then just say I want to seek unanimous consent to normally, so I know procedure from being on Procedure and House Affairs Committee, and I can't amend my own sub-amendment unless I have unanimous consent. But hear me out here. What I'd like to do is offer, in the spirit of compromise, collegiality, in the spirit of wanting to work constructively together, I would say, if you'll allow me, with the unanimous consent, I'd like to revert to the original wording that was proposed on the B, which was, whereas the processing of personal information and data should respect minors' privacy and their best interests. And I think if we can agree that then the sub-amendment that we would all support that I'd be happy to move that with unanimous consent if the committee will humor me.
A moment to have a quick check.
Of course. So I'll briefly suspend. Colleagues, I think we've reached consensus. So everyone's heard the what Mr. Turnbull seeks to accomplish with unanimous consent, which is to remove subsection B of his sub-amendment.
Yeah, if I can just clarify to
Yeah,
make sure
just to make
everyone's
sure.
clear. I think you're right. It's to retract the change to what we had in our sub-amendment, which was under B, to revert back to exactly the same wording that the Conservative Party had proposed, which is, and I'll just read it to make sure everyone is 100% clear. It would then read, whereas the processing of personal information and data should respect minors' privacy and their best interests.
And the rest. Okay, so do we have unanimous consent? Yes, we do. Amazing. So this we continue debate on the sub-amendment as amended. And I had on my list, if you're done, Mr. Turnbull, I had Mr. Perkins, Mr. Généreux, and Mr. Viss. Mr. Perkins, okay, so we're good to vote on the sub-amendment. If you no more comments. Okay, so the vote is, or do I have unanimous consent on the sub-amendment, or do I need recorded vote? Unanimous. Monsieur Garon, je vous regarde. Ça, c'est sur le sous-amendement.
Mr. Garon, we are talking about the sub-amendment as amended. I believe I have the unanimous consent of colleagues. That's great. So this takes us to CPC 1.
Ça nous ramène à CPC 1.
CPC 1 as amended. Should we open debate on CPC 1?
Are there comments on CPC 1 as amended? Shall CPC 1 carry as amended? Yes. Yes? Great. The next amendment I have on my list is NDP 1. I don't know if Mr. Massey wants to move it or not at this stage. Yes, Mr. Massey on NDP 1.
I don't.
Pardon? Yes, Mr. Turnbull.
Just again, I had checked earlier whether the two were dependent on one another or overlapping, and I think we had heard very clearly from the legislative clerk that they were not. But I think what we've just done in sub-amending that and agreeing to that, the CPC 1, that I believe it's already dealt with NDP 2. Could we maybe just take a moment and verify that, and so we don't get snagged in debating something that is not needed? Sorry, NDP 1. Yeah, sorry, that's what I meant. Yeah.
Yeah, we're talking about NDP 1, and it is true that there was a lot in common with CPC 1, but the end is not exactly the same. So if Mr. Massey wanted to move it, it would be receivable. But we can also just wait 1 second. I'll just briefly consult with the legislative clerks and come back to you. Okay. We still have 15 minutes, right? So we're on to NDP2. Okay, colleagues. No, because we started at 40. Okay, colleagues. So we have until 20 to 7. I don't know if you can say that exactly, but so NDP1, I gather, will not be moved because essentially it's been dealt with by the sub-amendment of MP Turnbull, which would bring us to NDP2. And just before it is moved, if it is moved, I'd just like to highlight that if NDP2 were to be adopted, G2 could not be proposed because there is a conflict of line. So should NDP2 be adopted? But I'll let Mr. Massé speak to NDP2.
Okay, so so the bill C227, I'll read this so people that are intently following at home. In Clause 2 be amended by replacing lines 16 and 17 on page 3 with the following, quote, modify personal information to ensure that no individual. And this comes, I'll just speak briefly to it and then maybe we can get into others could ask questions and so forth, from the Privacy Commissioner. And it's to strengthen the framework for de-identification and anonymized information. And so basically, it's to protect of de-identified and anonymized data, and it really comes from the Privacy Commissioner's recommendations that we've had.
Merci, Monsieur Massé. Monsieur Turnbull. Ensuite.
Thank you, Mr. Massé. Mr. Turnbull.
To Mr. Massey for putting this forward, and I wanted to. So my understanding is that Mr. Shan, maybe I'll start with you. Just that this specific amendment impacts the definition of anonymized information, and I believe it effectively removes generally accepted best practices as a concept from the definition of anonymization. Could you clarify that for me?
Thank you for the question, Mr. Chair. I'm just...
It's interpretation. It's page 3.
Apologies, I'm just orienting myself in the bill again.
Page 3, there you go. Anonymize. Reverse me permanently in accordance with...
That's right. So currently the interpretation clause reads, anonymize means to irreversibly and permanently modify personal information in accordance with generally accepted best practices to ensure that no individual can be identified from the information, whether directly or indirectly by other means. And right now, the NDP clause would remove the in accordance with generally accepted best practices.
Now, if I were to sort of ask you what, like, having generally accepted best practices in there seems to me to be a pretty high bar and an important concept that would potentially allow for the evolution of those best practices in a way to be kind of referenced in the bill, and that high standard, because I mean, I think I come from a world and did work before I got into politics where, you know, promising and best practices were things that we often talked about, that they would emerge specifically in areas where technology or innovation was happening, that it seemed to be fairly commonplace for fast-changing industries to evolve quite quickly, and that best practices, and I would say promising sometimes practices, were kind of the precursor to eventually determining best practices. So can you unpack for us the impact of taking that out? How would that, you know, impact the bill and the strength of the bill?
I'd raise two considerations. One is this would not be consistent with the definition that currently appears within Quebec's privacy law, which requires information to be anonymized according to generally accepted best practices. And so there would be deviation between those two, which is not in and of itself necessarily. They are separate statutes, but in terms of company obligations and in terms of how they'll actually be able to live up to both of those statutes, where consistency can be found, it can be very helpful. The other is generally acceptable best practices, as you know, is a well-established kind of construct that allows for standards, certifications to be able to continue to keep pace with the movement of the technology and of the construct. And I think absent it, it suggests that you're held to a standard without the notion that you are in fact to draw upon the state of the art as it relates to the meeting of the obligation.
Thank you for that. And just based on your knowledge and having done a lot of consultation on this bill, do privacy experts generally want this notion to be kept in the bill from your perspective? Like, have they advocated for or expressed any desire to have best practices, generally accepted best practices, included in the bill?
One is the desire for a high bar as it relates to the to the construct of anonymizing, and that generally acceptable best practices as it relates to that obligation for anonymize is seen by many to be a high bar. And then second, that I think there is a desire for consistency of application of the construct, which is why generally acceptable best practices ensures that there's standardized approaches as opposed to a potential patchwork or highly diverse attempts at trying to get to the anonymization of information that may not that may introduce other vulnerabilities because people are doing it very, very, very differently.
Okay, thank you. And as you've said, this would put our bill out of alignment with the Quebec Law 25, I believe it is, or Quebec's privacy law?
Require information to be anonymized according to generally accepted best practices.
Maybe one more clarification question. Who decides what a best practice, a generally accepted best practice is? Is it subject to OPC guidelines as well, or how would that be determined and identified for people?
Could issue guidance, and certainly in the field of anonymization, there are lots of folks who've done work in this space. But there's also considerable effort underway by the standards community and others to set out appropriate mechanisms for that, which include civil society actors as well as academics, and then those who implement the construct in real time.
Okay, so thank you for all those clarifications, and I think Mr. Massey, that's why, at least from our perspective, I think Mr. Shannon has provided a lot of clarification and rationale for why I would say our position is to oppose this one, just because we think that the generally accepted best practices portion of that wording in this particular clause is actually going to be quite useful to keep pace with the practices that are going to clearly evolve and emerge over time on anonymization. So just to provide rationale for our position, I don't know how others feel about this particular one, but certainly that's where we stand. Thanks.
Merci. MP Williams.
Thank you, Mr. Chair. And I think this is an important discussion. I'm sure this will spill over into our next meeting. And I thank the NDP for bringing up an important amendment. It's really important that we get the definition of an anonymized correct. We had a lot of witnesses that talked about anonymization versus de-identification. When I'm going to go off of what we were talking about before, the conversation was really about the balance between what business needs to interpret the risk uncertainty, and then the balance of what the body responsible for enforcing the laws that are in the Privacy Act, which is the Privacy Commissioner, the OPC, have to see as certainty. So not uncertainty, but have certainty when they're interpreting the law for privacy. So we really, and based on our last amendment, we really rely on the Privacy Commissioner to give us the best definitions that are going to allow them to uphold this Privacy Act. Because under the Privacy Commissioner and then the tribunal, they're going to need those definitions to be exact. And just to give an example, the Privacy Commissioner, Philip Dufresne, laid out a case for his appearance before the committee in the fall from our meeting on October 19, 2023, and I quote, "This bill says that more than can be done with de-identified information and that if it's anonymized, the law doesn't apply at all." So there's a big responsibility that comes with that. These definitions need to be strict in terms of how they interpret those definitions in the bill. And I think that's why we're spending a lot of time, even though it's a preamble and even though it's definition, this sets the tone for the rest of the bill, the rest of the conversations that we're going to have. So Section 6.5 of this Act exempts anonymized information from all protections the CPPA establishes. And given that our argument from this side, you'll hear more than once, is that privacy is a fundamental right, we're making sure that we get the definitions right. And when we go through this, the Office of the Privacy Commissioner's submission from May 2023 talked about this piece and said, "A final report relates to the new definition proposed for anonymized information as currently drafted. Organizations could anonymize personal information using generally accepted best practices. However, there is no explanation of what these practices are or what would be considered generally accepted. Including this language opens the door to the possibility that some organizations might rely on anonymization techniques promoted by certain experts or groups that are insufficient for a given data test or insufficient for a given test to what we're trying to define and what we're trying to enforce under this privacy law." So this is why it's very important. And we do have a problem, and as the Privacy Commissioner did, with including that language, general best practices. I know Mr. Turnbull just asked some questions, but do we have a list, Mr. Shan, of or do we have an actual definition, a legal definition of general accepted best practices? Or do we have a list that are going to be very specific for the OPC?
I think it's an evolving technology, and I think what generally acceptable best practices being in the statute allows is for the OPC to continue to pass judgment on whether or not the actions actually did conform to the generally acceptable best practices that have emerged. And I think we point to it as a means to encourage standardization of approaches and to ensure that people are living up to the best available opportunity to ensure the anonymization of the information.
And I think when we look at opportunity, we do want to look at business, and we were going to look at the some of the burdens that they see from this act, and they've come to the committee. They talked about compliance costs, regulatory burdens, impact of innovation, competitiveness. But when we also look at the OPC and what they need certainty. They need to make sure that they have clear definitions. They need to be able to uphold the law. It's no different than we look at the Competition Act and some of the definitions and the ways that they've looked to interpret that to enforce the law. We've certainly been very clear that we want to see the protection of children, certainly that privacy is a fundamental right. But I think this is a big one because this bill is not for today, it's for the future. So when we look at de-identification, you'll hear this further in some of the arguments we'll present. It still states, even in the definition, it says there's a risk that the individual still be identified remains, as in the definition of de-identification, where anonymization removes that. But to remove more of that nuance, to ensure that, generally accepted best practices, it doesn't define what those are.
Mr. Williams, as interesting as I think your comments are, we're reaching the end of the hour. So you'll have some time over the weekend to think about it, and we'll hear some more on Monday as we resume this study. Thanks to our witnesses, and we'll see you all on Monday. Meeting adjourned.